For hearing, item 1, Criminal Appeal 380/2023.
I want to know. Paragraph intercept. It will give you a sense. 912.
Yes.
Maybe Lordship. My Lord, this is second bail application. Earlier, that was rejected by your Lordships.
No, that's
So-
why you make your submissions on merit also. You are taking up both matters.
Appeal and IA.
Yes.
But today, my Lord, we are, I'm on bail matter, my Lord, actually. That is,
Because in this in this case, he has been taken into custody pursuant to opinion dated, sentence dated 16/12.
yes.
So he has served only about 3 years post conviction. But the Supreme Court has said that at least half of the sentence has to be undergone before he can be released on bail. We propose to hear the matter on merit.
The main appeal.
Yes.
But actually, my Lord, I'm sorry to say, I have only prepared for bail because the new ground is that the girl is married with the accused. So on that count, there are so many.
At the relevant point of time, she was 13 years with 7 months of pregnancy. That means she was impregnated raped and impregnated at the age of 12 years.
That there is a case and it is convicted. That is of course another matter. But since 2013, I am in impugned order that was passed on page 48.
Because you see, come to page 13.
Yes.
It's a positive statement of sexual assault.
No, I am not on that one. I am only that one. Suppose there was sexual assault without the will of the girl. Will is, when she is minor, her consent is also immaterial. But thing is this, it happened continuously for several months. And thereafter, but it was not reported. Incident happened on 15/12/12. And case is filed on 18/6/13. So there is a long gap, nearly 7 months. Now my submission is this, after all, intentionally or
Delay of
unintentionally,
7 months is because the pregnancy was detected at when the girl was 7 months pregnant. Then only family members.
no, my submission, what is my submission is that as they got married, so, and I am in custody since long time, so I may be granted bail.
Bacha also is taking care of the child.
The Supreme Court has said this matter, Supreme Court has said, when the parties have married, situation is separate.
Where is the marriage certificate?
Marriage certificate, my lord, that is not here, but it is admitted.
There was no social marriage.
Now, kindly see page 12.
There is no social marriage.
No, it is admitted by both the victim as well as her father. When facts is admitted, they need not be proved. So father says, yes, marriage took place, and the victim also says there was marriage. So at this time, I think this certificate, and these are not so much well-trained person, they did not collect that. That was not registered. Or now question is this: when they got married, after the crime, though it may be heinous, the Supreme Court says in many cases, when I have given the copies, one is 2025 live law I have given copy, that is Dipankar Datta. Sorry, K. Kiru Bakaran. K. Kiru Bakaran versus State of Tamil Nadu. Here Lordship would say, para 9. Para 9, last part may be seen. The appellant and the victim are not only legally married, they are also in their family way. While considering the offence committed by the appellants punishable under the POCSO Act, we have discerned that the crime was not the result of lust but love. The victim of crime herself has expressed her desire to live in a peaceful and stable family life with the appellant upon whom she is dependent. So, main thing is that was married. That is the main thing, as it was married. Whether they are living peacefully or not, that is not our concern, because there is no allegation to that effect. And then Lordship may kindly say, it is second 2022 SCC online, SC 1056 K Dandapani. Here, para 2, last part may be seen, para 2. He was convicted after trial for committing the offences and sentenced to undergo rigorous imprisonment for a period of 10 years by the session judge, fast track, Mahila Court, Tripur. Now, the High Court by order that so upheld the conviction and sentence, aggrieved thereby, appellant has filed this appeal. Then 5, after hearing the matter for some time, on 8 March 2022, we directed the district judge to record the statement of the prosecutor about her present status. The statement of prosecutrix has been placed on record, in which she has categorically stated that she has 2 children. They are being taken care by the appellant and she is leading a happy married life. Then para 7, in the peculiar facts, this is peculiar facts. This is peculiar facts. That before the incident may be something, but after that she got married with the victim. So court says, in the peculiar facts and circumstances of this case, we are of the considered view that the conviction and sentence of the appellant, who is maternal uncle of the prosecutrix, deserves to be set aside in view of the subsequent events that have been brought to the notice of the court. So subsequent event, marriage matter we have brought. This court cannot shut its eyes to the ground reality and disturb the happy family life of the appellant and the prosecutrix. We have been informed about the custom in Tamil Nadu of the marriage of a girl with the maternal uncle. So what is my submission in this case would be that he should be granted bail. Setting aside the sentence, I am not at present on that, because we have filed IA. Then similar view has been also expressed in the case of Dashari Srikant. In para 3, it is the story has been changed, and then para 6 onward. As it is evident from record that the appellant was initially charged for the offences under section so and so, and section 11 read with section 12 of POCSO Act. However, learned trial court did not find the offences under POCSO Act proved and acquitted, and the accused appellant from the said charges. The offences under section so and so are personal to the complainant. Now personal. Now, my lord, what thing happened between the two, they are personal matter. So personal matter, if I forgive or forgive it, it should be presumed. Because when marriage has taken place, it is presumed that the parties are happy. Parties are happy. So the court, as in para 9, it is said that as a consequence, we are inclined to exercise the powers under Article 142 of Constitution of India for quashing the conviction. Now, High Court will see that under Section 482. That is former CRPC. Now, my submission is this: court has repeatedly said when the parties are in a mood of compromise, it may be something similar view. Sri Ram Urav, kindly Sri Ram Urav, para 14 and 16. Para 14, on reading of the aforesaid paragraphs, we note that in those cases also the appellant, accused and the complainant victim had married each other, just as in the instant case. Therefore, we exercise our powers under Article 142 of the Constitution of India and quash the conviction. So, I am not setting aside the sentence at present because today I am on bail. So I think, my lord, this spirit and the principles of law laid down by the Honorable Supreme Court in these cited cases very soundly it appears that he is entitled for getting bail. Even since last 22, he is in custody. And before at the initial stage, when he was arrested, he was also in jail. So all these things, if we take together, then it will be more than 3 years. It will be from that is from 16, 12, 22. Earlier, more than 3 months. So it will be almost 22, 23, 23, 24, 25. 4 and 5 years, my lord. 4 and 5 years. And now this is also Himachal Pradesh High Court has granted bail to the POCSO victims in Ranjit. So when there is also a judgment that bail should be granted liberally. When more than 4 years he is in custody, at that time I think it is a division bench order of the High Court, which High Court? High Court, Himachal Pradesh. Para 41 may kindly be seen. 41. According to the facts of the present case, no doubt, the accused has been charged for the offences punishable under Section 366, 376, 212, and 120 BIPC and Section 4 of the POCSO Act. But then it cannot be ignored that criminal prosecution was set into motion only because the victim happens to be a child, but otherwise she was in love with the accused. It is also not in dispute that
Yes.
all these things, my lord, that is, this criminal motion was initiated by the girl, and the girl is now got married, and the court has discussed various judgments in this case, various judgments of the Honorable Apex Court, and finally, court found that maybe it's in para 46. The court, on the basis of the material placed on record, has satisfied.
Who is Purno Arjia?
Miller,
Who is Purno Arjia?
Pranab
Father.
Arjya, father. Father has also said merit. Purno Arjya, father, and he also admitted that they got
Mr.
married.
Mahmood, why do you take the trouble of telling us all this when you are misleading the court? Come to page 20.
Misleading? How have I misled?
Look at page 20, will show you.
This Purno Arjya is the father, complainant.
Yes.
That is page 16.
Cross para 1.
Page 20. Page 20. Page 20. Yes. Further cross-examination.
Para
Eh,
1.
This is further cross-examination of Purno Arjya. The victim is presently married to another person. The victim had eloped and married about 11 months ago. So it means that she was another person. Again, that
So you are misleading us. You were all throughout submitting as if the accused and the and the victim had married. Don't do it.
no.
Don't do it.
My submission was that
Don't do it.
if she has got married with
You're
another,
calling unnecessary, what do you call, amendments in our order. Don't do it.
now what was my submission that she got married? If thereafter she got married to
Mr.
another
Mahmood,
person.
we will be too harsh in our order. Don't repeat it. When you are misleading, don't repeat, don't justify your misleading of the court. We'll be very, very harsh. We leave it to you. We have said only once, we'll not repeat again. You make your submissions, whatever you want to do.
Next. Well, my prayer is to grant bail. Long suffering in custody, so bail may be granted. Earlier, your lordships rejected the bail, but that point was not asked by us. On this new point, we have filed this petition, so
Where is the statement in this interlocutory application regarding the marriage?
yes, that is. That is. Page 12. Make it page 12 of the paper book. At that
No,
time, the accused.
in this IE where you have said with regard to the marriage.
Yes, married, I am saying, page 12 condition. Page 6 of the IA. IA page 6 that is mentioned.
Which line? Just tell us which line.
Page 6, para 6.
Para 6, we have it. It's a very long paragraph. Just tell us the line number where you said about the marriage. Mr. Mahmood. Mr. Mahmood,
My lord.
even in your dreams, we'll be more prepared than you. Your statement is not there. Your statement is at paragraph 4. And that is again a misleading statement.
She got married, that was mentioned, but again remarried, that is not mentioned. That is not mentioned. Well, I am withdrawing this IA and let the main case be listed for hearing. Kindly, para 4. The applicant begs to state that the Lana trial court convicted the accused person even though it was a fit case for bail, as the applicant has now married to the girl and also have a child together. So, this is the statement by the affiant. Affiant, who is affiant here, my lord? Now, we do not go to their house. It is Tara Mandal. Tara Mandal, sister of the victim. So she has said that she got married, one child is there. So now if, so far I admit that, again it is married to another person, that is another matter, and that I admit. That is not disclosed here. But here is only for bail. So I am withdrawing and let the main case be listed for hearing.
We'll refuse. We'll refuse because of the incorrect statement. You made an attempt, and therefore we also drop a criminal proceeding, criminal contempt against you. We have given you fair warning. We told you once that we will be very harsh on you. You still insist on that statement that that the victim married the applicant, and you are now justifying by reading paragraph 4 that the what you call the applicant is someone else. He married the victim girl. That is what you are projecting. Tara Mandal, you said, had married the girl. Tara Mandal.
Tara Mandal is sister.
Tara Mandal is sister. So sister married the victim girl.
No. She, her information is that. She provided the information.
Correct. That's why we are drawing up contempt against you. This is something we will not tolerate. We gave you a fair warning that will be very harsh on you. You insisted, you perpetrated, you are repeated again. This is for the 3rd time you are repeating. We will refuse your prayer and will drop contempt. This is something we will not permit. You can't mislead the court. Had we not read and come, we would have misled us.
No, that is not my intention. How
We
will
are
be?
getting four judgments to supplement it that they are married, happily married. You did everything in your power to mislead us. Sorry.
No, my lord, I actually, that was not my intention to mislead, but something I have not disclosed. It is a very
That is your
matter.
intention.
So kindly,
Your intention is absolutely clear. Your intention was repeated thrice in your submissions. Your intentions are repeated in paragraph 4 of your petition. Your what you call the statement made in paragraph 4 is true to our knowledge. In the affidavit at page 9, you have cited 4 judgments on the ground that they were happily married. What else the intention can be? We close this business once and for all. We don't want to be misled. We have given you a fair warning. We told you that we would be harsh. You still insisted. After that, you have repeated this for the third time. After being given a fair warning.
But I expressed my sorry, sincere. So this IM may be take as you don't.
No, you are not doing it. We close it, but still the content will be drawn up. Third, Mr. M. U. Mahmood, learned counsel for the applicant. Also heard Mr. J. Leonard for the state of. Next. This is a second application by the applicant under section 430 of the BNSS for suspension of sentence passed by judgment and judgment dated 16/12/2022 in sessions case number 110 within bracket capital B bracket close 2018, arising out of Bijli PS case number 133 of 2013. So, by the said judgment and sentence the applicant, who is the appellant in the connected criminal appeal 380 of 2023, was convicted under section 376 IPC and section 6 of the POXO Act, 2012. Consequently, he was sentenced to undergo sentence only under section 6 of the POXO Act to undergo rigorous imprisonment for life and to pay a fine of rupees 10,000, and in default to undergo simple imprisonment for another 6 months. Next paragraph. The learned counsel for the applicant had submitted that on an earlier occasion, when the application for suspension of sentence passed against the applicant was being IA criminal 989 of 2023, the applicant did not raise the plea that he was married to the victim. Accordingly, on the said new ground, the present interlocutory application has been moved. Next. In paragraph 4 of this interlocutory application, the following statement has been made, which is verified to be true in the affidavit filed in support of this application. The said paragraph reads as follows. Is extracted below. Paragraph 4, page 5 of the IA. Next paragraph. In just give that citations. The grounds that pursuant to the sentence passed on 16/12/2022, the applicant has been taken into custody and is serving sentence and thereby has suffered incarceration of about more than 4 years. No, more than 3 years. the learned counsel for the petitioner has cited the four following cases. Sorry, that's it. See to that. Next. It may be stated that in course of his submissions, the learned counsel for the petitioner was given a fair warning that he is making an attempt to mislead this court, which he denied and which he had denied and made his submissions on merit. Full stop. Thus, having heard the learned counsel for the petitioner, he was put to notice to the further cross-examination of PW2 available at page 20 of the A4 book. Full stop. In paragraph 1 of the further cross-examination, the PW2, who is the father of the victim, within bracket name withheld to maintain non-disclosure of, what is it called? Not to reveal identity. Name not disclosed, not or to not reveal the identity. Had stated that, inverted comma start, the victim is presently married to another person. Full stop. The victim had eloped and married about 11 months ago. Thus, not only the applicant has taken a false plea in paragraph 4 of this interrogatory application, that the applicant has married the victim but the learned counsel for the applicant, knowing the statement to be false, attempted to mislead the court not only by his submissions but by citing the cases referred above. Next paragraph. At this stage, the learned counsel for the applicant says that the applicant may be allowed to withdraw the application. Next paragraph. Notwithstanding that the prayer to withdraw the application is allowed, but as the learned counsel for the applicant, despite being given notice that he is making an attempt to mislead the court, continued with his submissions, and therefore the learned counsel for the applicant is put to notice as to why a criminal contempt should not be drawn up against him for making an attempt to mislead the court and thereby affecting the administration of justice. First off, the said matter would be taken up by way of another interlocutory application. Accordingly, the registration register a separate interlocutory application for hearing the learned counsel for the applicant on the query of the court. Next part, yeah, this IA number, this interlocutory application stands dismissed on withdrawal. However, with direction to register another interlocutory application to consider the query of the court.
Happy hearing of the
Yes, sir,
SC.
happy. Wow. What was the presentation? I think paper was prepared, at least the matter for hearing on. It is okay. Not sure. Okay. It is. Think the part.
Happy Lordship. With the concern of the petitioner, I beg to mention item number 13, 14, 15, 16 Lordship. Today's supplementary
Pardon me?
hearing later.
Item number
13, 14, 15, 16 Lordship.
petition. It's 2017 matter.
17 later. Lordship, senior counsel AK Professor yesterday while returning back to his residence, he
Pardon
met
me?
with an accident.
Pardon me?
AK Professor senior counsel while returning from the court to his residence yesterday, he met with an accident. Lordship.
Yesterday, he met with an accident, my lord.
So he
Oh,
got some
sorry.
injuries in his legs and
I'm sorry. Okay. Anything serious? No.
no, not really. But some injuries in the hand.
Item 13, 14, 15. Also is represented. Date 10th of March. Sorry, what is it? Sir,
S. Sharma, Lordship.
S.
S. Sharma. My name is there in item number 16.
Learned counsel for the
Respondent in
for
item
the
number.
respondent, private respondent.
Yes, Lordship. In 15,
has
item number
submitted
15 and
that
16.
that Mr. AK Purkasar and counsel holding the brief has suffered accident on 2nd February 2026. Next, accordingly on this, the matter stands adjourned today. List on when
10th of March, madam.
10th of
10th of March.
okay, 10/3/2026. Okay, I'm sorry. Yes.
Obliged.
I'm aware of his accident.
May I please, your lordship, with regard to item number 10 and 11, my lord, the matters have been substantially heard by court number 1, my lord.
10 and 11. Is that it? It has been something that this matter was substantially heard by the division, by the division bench of court number 1. Accordingly, the registry shall examine and list the matter before the appropriate. judge.
5th of March, if you-
5th of March,
after examining, it may be fixed.
5th of March
5th of,
5th of March.
on 5/2/2026.
obliged, your lordship.
My lord, I want to go through the item number two.
For him, you may allow any time, huh?
Oh, which?
You not have to make, you just the court master will permit you. You need not make a prayer before the court.
Supplementary item 12 to be spoken to.
Yes.
Today, they have informed us, Lordship, today, that I think today they are going to release. So we'll submit that, after that I will inform them. Replace কৰি দিওঁ। তাকে। মই কোৱা নাই, আজি হেৰি কৰিব কৈছে, এখন দি দিম। Lordship. Lordship.
Item 1 for hearing. Item 2.
May please, your lordship. Here the impugned order as page 42. Sonaka আৰু Sonaka আৰু এই তোমাৰ ৰফিকা বিবি তো বেগত আছে সেইটো আনিব লাগে my lord here in this case my lord the reference was made based on LBO report ৰফিকা বিবিৰ বেগত আছে মাষ্টাৰ ফাইলত আছে my lord based on LBO report and LBO report, my lord, there is no indication what is the charge, my lord. What is the period of entry that has not been identified. That is one point. I have hurriedly could go through the Malayalam LBO report. My lord, my lord. My lord. No, my lord, that part which is required, I have seen, my lord. LBO report is at page 18. 18, my lord. The LBO report pertaining to column 16 and 15, my lord. There is no indication in which period the petition has entered. The other part, column 1 to 3, I think filled up, but other part simply no documents has been mentioned, but nothing has been said about paragraph column 15 and 16 about the charts. Nothing has been mentioned. My lord, my next point is, my lord, the notice, my lord, indicated notice also in the record. Notice at page 21 of the record. It indicates two charts, my lord. 1166 to 25 1997 slash 25th March 1971. So, my lord, two charts. Two chart is not maintainable. Chart should be specific in the case of foreigners. That was not there. And the LBO report indicates no charts. Simply documents not submitted. So this goes to show that the reference was made mechanically. Topika reviews is true idea.
Madoka jana na itu kaya fine. Back. One order fine too. I got it fine.
my lord. Then, my lord, my lord, we have two judgment, my lord, for not mentioning the charge. Lordship has passed one judgment. Rofika Bibi, I fail to collect that copy. I can furnish it later on, my lord. My lord. Rofika Bibi. Then, my lord, there are some other judgment also. For not being specific charge, there are other judgment, but I want to rely on the Rofika Bibi case. And so for the notice, my lord, mentioning two charges, the judgment of Sunakha. Sunakha is reported as 2021 3 GLT. My lord. 2021 3 GLT, page 12. My lord. Then, my lord, if we come to, my lord, this judgment, my lord, the impugned judgment, the judgment goes to show that the tribunal has found fault correcting the father's name by hand. My lord, in WS and evidence, both WS and evidence, father's name has been corrected by hand. And that was found fault. That is one point. Whether, my lord, for correcting by hand will be fatal to discard the entire evidence. Then, my lord, the Gabura evidence has not been accepted. May I read the, my lord, the relevant part of the judgment, my lord? It starts from page 42, but I want to read, my lord, from page 43. The OP in support of our claim, two witnesses, namely DW2 Rofiqul Islam and DW3 Shukur Ali Ahmed, have examined besides proving 6 documentary evidence, namely 4 numbers of certified copies of voter list of 1966, 1970, 1989, 1997, and 2 numbers Gabura certificate marked as Exhibit 1 to 6. A certified copy of 1966 voter list, Exhibit B, electoral roll of 1970, Exhibit C, certified copy of 1989, Exhibit D, 97 voter list, Exhibit F, Gabura certificate of Digir Pam, Exhibit F, Gabura certificate of Sesra Digir Pathar. One is from her paternal side, one is from her matrimonial side. Then, my lord, I have, my lord, Digir Pam. My lord, I have annexed yes, my lord. Yes, my lord. Digir Pam is from paternal side. Rofiqul Islam. Gabura's name is Rofiqul Islam. Yes, my lord. Other one is Shukur Ali Ahmed. He is from matrimonial side, Digir Pathar. Then, my lord, I have perused the case record, the WS evidence in chief on affidavit, the oral testimony and the cross-examination. The OP in her evidence defense has pleaded that her father Tukmia and mother Muiron Nessa Muriam Khatun name had been appeared in the voter list of 1966 and 70, 1989, 1997 at village Digir Pam under P2 number Bagbor LSC, district Barpeta, The further addition is that OP's mother name has appeared in the voter list of 1989 as Moriam Khatun instead of Moriam Nessa at village Digirpam under 45 number Bagbor LSC. This must only she had pleaded in the WS and more or less stated the same evidence in sheep on affidavit which she pleaded in her defense. On scrutiny of written statement, it is civil that while the OP disclosed the name of her father Tukumia in the written statement, and evidence on affidavit has also written allies with the name of Sirajuddin with hand and pen without putting any initials. No explanation and clarification has been furnished by the OP in this respect. Further, the OP failed to disclose her grandparents' name. She also failed to mention the family members of her father, grandfather, names of brothers and sisters of the OP. The OP could not disclose her date of birth, place of birth, but in affidavit, she disclosed her age 42 years and birthplace at Digirpam. It is well settled proposition of law that party cannot travel beyond the pleading. What is pleaded can only be proved and not something which is not pleaded. Her failure to disclose to such material facts of the first instance may lead to drawing of adverse inference against the proceeding. Moreover, due to non-disclosure in her WS and evidence, it by any means cannot be said to be wholly adequate to establish an identity as a citizen of India, having regard to the mandate of Section 9 of the Foreigners Act 1946, as explained by Supreme Court in paragraph 26 of Sarvanda Sonal case report so and so. The OP claims that her parents are the recorded voter of 1966, 17, 89, 97. It is seen that the OP Zohra Khatun exhibited 4 numbers of voter list of Exhibit A, B, C, and D, the electoral roll of 1966, 70, 89, and 97, 1966, 70, 87, 97. Interestingly, OP neither in her WS nor in her evidence on affidavit mentioned whether her parents are alive or dead. In this regard, OP has not provided any clarification. The OP claimed that her witness appeared in the voter list, nor are any relatives have appeared to prove the contented voter list of so-and-so. My lord, this is very important, my lord. And the tribunal held that this voter list certified copy of voter list are to be proved to establish linkage of the OP Zohra Khatun with her parents whose name appeared in the voter list of 1966, 70, 89, and 97. The OP has only relied upon Exhibit E issued by Gabura of village Digir Palm Charge 2 and Exhibit F issued by Gabura of village Sesra and Digir Pathar. It is certified in Exhibit E that Zohra Khatun, daughter of Tukumia alias Siras, was the resident of village Utpurpam, Digirpam, PS Bagbor, district Borpata, married to Shahjahan Ali. On examination of DW2, Rafiqul Islam stated that his present age is 29 years and working as Gabura since 2012, and he knows Zohra Khatun since his childhood. It is certified in Exhibit F that Zohra Khatun, wife of Shahjahan Ali, is a resident of Digir Pathar. On examination of DW3, Shukur Ali Ahmed stated that he knows Zohra Khatun, wife of so-and-so by DW3 since 20/22 years, and she is resident of village Digir Pathar. After scrutiny of evidence of DW2 and DW3, I find that they know the OP as a resident of Digir Pam and Digir Pathar respectively since last 20/20 years as resident of their respective village from the date of recording of their evidence on 8/5/2017, and that means they know the OP from year 1997, and certificate was issued in the year 2016, and means it is issued after reference was made against the OP. Further, both the certificates Exhibit E and Exhibit F have no memo number or issue number. The documents issued by the Public Affairs can be acted upon as a linked documents, but it has to be borne in mind that these officials can issue link certificate only when their office maintain any such records. That certificate can be issued. So these certificates of Gaura cannot be considered as link certificate to determine the Indian citizenship. Indian citizenship of office, which shows that OP has failed to establish her linkage with her parents. Further, OP would not produce any certificate to the effect that she was born in Assam, although she claimed her citizenship by birth. The documents submitted by the OP are not sufficient to establish that she was born in Assam and to claim her citizenship by birth. Mere filing of some documents and picking up any name from such documents so as to establish relationship with the said person as father or mother or grandfather, grandmother does not amount to proof. Under the law of evidence, mere admission of documents marked as exhibit does not make the document admissible in evidence unless the contents of the documents are proved. In this case, the net result is that the OP failed to prove the contents of the documents by not establishing the entries of the voter list belonging to her parents. As such, the purported voter list procured in the name of her, a name of other person projecting her parents are not reliable and trustworthy document. The OP has thereby failed to discharge her mandatory burden of proof and as envisaged under Section 9 of the Foreigners Act 1946. In view of the above finding, this tribunal is of opinion that OP is a foreigner illegal migrant had entered into Assam on or after 25th March 1971 in exercise of power conferred under 313 of the Foreigners Tribunal Order 1964. The OP, namely Zohra Khatun, wife of Sonso, to be taken into custody immediately and kept interning of the Foreigners Act in appropriate place till she is deported, pushed back to her specific territory. And the reference case is answered in affirmative. My lord, this is the order, my lord. जुबेर पागला क्यों दो?
এই রফিকা বিবি রেকু
আচ্ছা আচ্ছা
Petition number.
ভেরি গুড
প্রসেস পাস
একটু অনলাইন কপি ওলাব পারা যাব নেকি আর পৰা
পারিব 7 তে উঠি যাব স্যার
আচ্ছা My lord, I got the number of Rofika Bibi, that is WPC number 3330 of 2020. RAFIKA, Rofika Bibi. Yes, I spelling to WPC 3330 oblique 2020.
রফিকা বিবি এন্ড রফিকা খাতুন
My lord, 3330 oblique 2020, judgment dated 26/5/2025. My lord, I will furnish a copy, my lord, but I am giving the number at this time. Rofika Bibi alias Rofika Khatun. My lord, my first point is, my lord, the learned tribunal, my lord, hold a view that the documents voter list of 1966-70, the voter list which are produced certified copy, those are not proved. That is the my lord, first negative point. The documents are not proved.
Please repeat again. I missed it out.
My lord.
What was your submission? I missed it out. Please repeat the submission.
My lord, my first point is, my lord, the tribunal held that documents are not proved. My lord, we have produced the voter lists in certified copy. তাতে কৰি টাইম ল'ব লাগিব উপায় নাই। My lord, in page 44, the page 4 of the judgment, in the third paragraph, this has been held. The contents of documents are not proved. This is the first point, my lord. Then, my lord, the Gabra evidence has been in two discarded. My lord, one of the Gabra, my lord, the one of the Gabra has clearly said the parental Gabra, the Gabra from parental village, Rafiqul Islam, he has said, I know the opposite party, Zohra Khatun, since childhood. My lord, the vernacular portion is like that, my lord. There may be mistake in translation. এই গোচৰৰ দ্বিতীয় পক্ষ জহুৰা খাতুনক সৰুৰে পৰা চিনি পাওঁ। তেওঁ দিগিৰ পাম গাঁৱৰ বাসিন্দা আছিল। তেওঁৰ দেউতাৰ নাম মৃত টুকুমিয়া দিগিৰ পথাৰ গাঁৱৰ শাহজাহান আলীৰ লগত বিয়া হৈ তাতে বসবাস কৰি আছে। So, my lord, this evidence of the Gabra is impressive, my lord. Because he is hailing, he is Gabra of that village, he is hailing from that village, and the proceed is parental village. So he knows the parent of the petitioner. The manner of discarding the Gabra evidence is not proper. Then, my lord, the tribunal has declared the petitioner as a foreigner of entering into Assam on or after 25th March 1971. Where is the charge, my lord? The notice has been issued showing two charges. And the tribunal has not subsequently made any formal order modifying the charts. And the inquiry report, more interestingly, my lord, the LBO report, the proceeding, the reference is based on the LBO report. LBO report is totally silent as regards the charts. I'm leaving, my lord, other points, but the LBO report has not categorically said what is the charts. On what basis the reference was made?
Yes.
My lord, the brutalist are not required to be proved, my lord. There are so many judgments of this honorable court, my lord, and the Supreme Court also, my lord. Supreme Court judgment, my lord, AIR 1963, Supreme Court 1633, M. Ramappa and another versus M. Buzappa. Then, my lord, in our High Court,
M. Ramappa versus
M. Ramappa and another versus M. Buzappa.
M.
M. Buzappa.
How do you spell it?
My lord, M. Buzappa means spelling is M full stop BOJAPPA. Buzappa.
Reported in AIR.
AIR 1963, Supreme Court 1633.
Paragraph.
Paragraph, my lord, Sorry, my lord.
It's okay,
The
later on you-
documents are also not genuine and could not have,
It's okay, later on you can give it.
my lord.
When you, if that's valid.
In
Sit down, Mr. Siddharth.
my lord,
Sit down and read it.
my lord,
Don't have to stand up. Sit down and read it.
my lord.
No, we are giving you time.
My lord,
Sit down and say it.
My lord.
Sit. Sit
My
down,
lord.
please.
my lord, my lord. Relative evidence. The line has said this public hearings. পঠাই দিব পাৰিলে ফাইলটো আনিব অনাওতো ওলাই ল'ব পাৰিম অনলাইনো ওলাই ল'ব পাৰিম
Information দি দিব পাৰিম। Showcase টো কৰি লওক।
মুজিবুর মিয়ার কেসটো ক'ত আছিলে পঁয়তাছ I got the paragraph, my lord. Paragraph 9, my lord. Paragraph 9, my lord, part 46, 7, 8. In the 8 and 9 line, the statement is like that, my lord. The document in question being a certified copy of a public document need not have been proved by calling a witness. Then, my lord, in our High Court, there are so many judgments. I want to refer, my lord, the Mozior Mia versus Union of India, 2020, 5 GLT 395. In this case also, my lord, Mojibur Mia versus Union of India,
How do you spell it? MO?
MAJIBAR, Mojibur, MIAH, Mia.
This is WPC?
My lord, it is
No,
reported case,
Okay,
my lord,
yes, yes, please give me-
2020, 5 GLT 395.
Yes.
My lord, these two one I want to refer, my lord. There are so many other judgment, my lord, in passed by the Odisha High Court in division bench, single bench. But I think these two is sufficient, my lord.
Yes.
My lord, Then, my lord, I want to refer, my lord, the judgment of the Sunakha
On what point?
on point, my lord, charge in the notice charge is 2. In Sunakha case, my lord, this honorable court has held that charge should be 1 and specific. My lord, in the foreigners case, normally there are 2 categories foreigners. One is of stream 66 to 71 and post 71. The notice contains 2 charts. The Sunakha versus Union of India and others reported 2021 3 GLT page 1-2.
Yes.
In this case, my lord, it is held, my lord, that charge should be 1 and specific.
Yes. You are referring to 2 decision, in fact, Sonakha and Rafika Bibi.
Rafika Bibi, my lord.
Yes.
Rafika Bibi has, lordship has held that when the investigation LBO report is not giving any specific finding on the charge, then the reference is mechanical. This, my lord, and the learned tribunal has found some fault, not giving details of the place of birth, date of birth. Place of birth she has mentioned, and date of birth has not mentioned, but she has mentioned her age in filing the in the WS. He has mentioned in her verification report about the age. The same is also mentioned in the evidence in CIF as well as the my lord cross examination. And at no point the defense has made any cross examination. The only, my lord, the tribunal has made some query in both the evidence of Gabura, two Gabura. The tribunal has made query, but no state cross examination by the state. So, my lord, what we have stated in evidence and CIF or cross, that has to be accepted as a final. This much, my lord, at this stage, my lord, my submission. And for some fault here and there, should not be taken up as held by the Honorable Supreme Court in Sirajul Haq case and Rohim Ali case, my lord. These 2 judgment is also important, my lord, is to be referred, my lord. My lord, in Sirajul Haq case, 2019 5 SCC 534.
Just a moment. 2000.
2019 5 SCC 534. And Rohim Ali
What are
judgment,
the paragraphs, Mr.?
paragraph, my lord, only 4 paragraph, my lord, in this case, my lord.
Okay.
Paragraph 3 and particularly, my lord, 4 is relevant. 4, 5, page 25.
And the other is,
My lord,
and the other
my
judgment
lord,
is?
other is, my lord, Rohim Ali judgment, 2024 4 SC 97. It is
2020
GLT publication, my lord.
2024?
2024 4 SC 97. It is GLT publication, my lord.
Okay, GLT.
Yes, ma'am.
Volume?
My lord, 2024 4 volume 4,
GLT.
SC 97.
97.
97. Here, my lord, there are Supreme Court has
Can you
in
tell us the paragraphs also?
paragraph. I basically rely on paragraph 44. In paragraph 41, the Honorable Supreme Court has said so many things, my lord. But paragraph 44 is sufficient for us, my lord.
Okay.
It is clear that there are minor discrepancies in the appellant's documents, however, their authenticity is not in doubt. In the considered opinion of this court, the same would further buttress the appellant's claim that not being in the wrong and being an ignorant person. My lord, I am also relying on the, my lord, my lord, Sarvanda Sonowal, one case because paragraph 26. In paragraph 26, there is one line that when the procedure is evidence, the state should rebut it, verify it, and if required, adduce rebuttal evidence, but no rebuttal evidence.
Yes.
Sarvanda Sonowal, my lord, 2005, 5 SCC, 665. Then, my lord, here, my lord, I also rely on the Muslim Mandal judgment paragraph 117.3 and 112.1, my lord.
Just a moment. In this names, you said in voters list, there are some discrepancies. Can you just identify those very
Discrepancy,
entries of whose names there is a
my
difference?
lord, discrepancy in the voter list, there is no sense discrepancy, but father's name, my lord, in some documents, father's name is written as Tukumia all along in voter list, but only in voter list 1970, the vernacular goes to show that it is written as Tobakumia. But say 66,
In
see-
voter list of which year?
1970, my lord. In my
70.
petition, lordship will find at page 24. But 66, it is correct,
1970.
my lord. But 66, then 89, then others, and 97 voter list, father's name is correctly written, Tukumia. And in the WSN evidence, there has been correction because I think, my lord, in land documents, the father's name is written as Siraj Ali. Therefore, this correction was made. That correction, my lord, the land document is also not produced before the trial court. And, my lord, I want to show your lordship, my lord, one document, my lord, page 49. The Barlangular at page 50. She is voter with her parents. Father's name is Tukumia, mother's name Muriam Khatun. Her name is Zohra Khatun. But this was not placed before the trial court.
Yes.
My lord, my last submission is that, my lord, the tribunal ultimately held that documents are not proof. My lord, Thereby, my lord, it is held that the certified copies of voter list are required to be proved, which is not correct, my lord. That is my last submission, my lord.
Just give us 2 minutes, we'll take a short break and come back.
The record, I have the record. From record, I wanted to. Because my running friend has not computed. That the LBO report, as there is no method. So. Reference itself is correct. Another from that Malan, your friend has already said, Mati, the LBO report, it is stated. My learned senior friend has already said, my lord, from the LBO report, it is seen that only no documents produced is there. So in entire, my lord, 3 pages, it is thick that no document is produced. As your lordship, no, knows it well, my lord. This I have argued many occasions this point, my lord. There's this, my lord, the provision of, my lord, making reference by the, my lord, year. This is as per the, my lord, direction of the Election Commission of India. There was a guideline in 1997. And that guideline, it is clearly said how reference is to be met.
Police.
Yes.
My lord, first of all, I like to read the, my lord, the reference by the year. How it comes, it will be clear from this, my lord, reference itself. This is by the election year, my lord. It is said Office of the Election Registration Official, so-and-so Assembly Constituency. This was on 19 November 1997. But the date has to be, but it is very important because at that time the IMDT was prevailing, my lord. Why I'm saying this? In IMDT, there was no provision of 6671 or 71 stream, my lord. There's only one stream, that is 1971. In IMDT, there was no provision of, my lord, 6671 or 71. There was no provision as such. So here it is said, my lord, whereas the Election Commission of India has ordered intensive revision of election rule of the so-and-so Assembly Constitution Assam with reference to 1197 as qualifying date. And whereas the house-to-house enumeration was done during the period of 16 January 1997 to 15 April 1997. And whereas the name of Srimati Jahura Khatun, the proceeding, so-and-so, who declared to be an Indian citizen and also an ordinary resident of Dighar Pathar address, has been enumerated for inclusion in the draft electoral roll. Her name was entered in the draft electoral roll in 1997. Whereas the electoral roll of the said constitution was published on 24 July 1997, including therein the name of the said Srimati so-and-so. And whereas I, the electoral registration officer of the said assembly constituency, having doubt My lord, this was the having doubt about the citizenship of the said person, got the matter verified by an on the spot local verification, which is the local LVO, my lord. And that is the report. He considered the report, got the matter verified by an on the spot local verification. And whereas on consideration of the report of such verification, I have reasonable doubt that she is not a citizen.
Mr. Payam,
Madam.
once you are referring to this argument,
Yes,
I think you have made the argument earlier also.
yes, madam.
You gave us one copy of the manner of
Yes.
verification. I think I misplaced it somewhere.
I have the guideline, madam. One copy. Soft copy, probably I can provide the soft copy, madam.
Just first that.
I have only one copy, madam.
No, it's okay. That's okay. Wait. You had given it to us, the
Yes,
It's a big one. If you can have it mailed to us, we'll.
Yes,
have
yes,
it.
I'll,
You need not make photocopies, just
Yes.
give us a.
yes.
an email.
So that point is clear, my lord. After the LVO, if LVO report does not contain anything, the ERO has no option but to send the matter to the foreigners tribunal for determination. He has to satisfy that on the basis of report that yes, his name can be continued in the voter list of 1997. So then it has to be, there is no option but to send the matter to the foreigners tribunal court. That is the simple point, my lord. And it is clear, my lord, during 1997, secondly, my lord, I argued this point earlier also. In Sobananda Sunwal 1, para 41, 42, has clearly said this, my lord, the forms, the materials which are to be collected by the investigation officer or by any other person from the person who has come from East Pakistan may not be possible. That's why it is said the form or the materials which are suppose the person who has come from East Pakistan, he will not disclose that he has come from East Pakistan on this date. He will never disclose this. That has been said by the Supreme Court. That's why Supreme Court said that these materials, collection of these materials are not necessary. And as such, my lord, as these forms are part of the, my lord, IMDT, my lord, rules. These forms are part of IMDT rules, and these materials are to be collected as per the IMDT rules, man. So Supreme Court has said this is not possible for an investigation officer or a person who want to give information to the police that this person is coming from East Pakistan. It is not possible on the part of the prosecution side, the police or the informant to give this, collect this material. That's why under para 83, this rule is also been set aside. The rule is also set aside under 83. So that is not. The third issue, my lord, I also argued this point, my lord. As per my lord, this from record it is clear, my lord, this proceeding started in 1997. These were transferred, my lord, the IMDT tribunal was there. There was a committee. Prior to that also, committee approves. Then only after approval only, my lord, this goes to do. This case goes to the, my lord, the tribunal. Now in Sabananda Sunwal, my lord, the tribunal got the jurisdiction from where? Tribunal got the jurisdiction only after 2005, foreigners tribunal, my lord. The Supreme Court has said only matters irrespective of pending, wherever it is pending, my lord, has to be sent to the foreigners tribunal for disposal as per the Foreigners Act 1946. Under the, my lord, the procedure of 1964 orders. Now, my lord, those matters which were transferred by the Supreme Court, irrespective of, my lord, as I have already said, my lord, the IMDT was set aside, my lord. There it is because the procedure laid down in the IMDT was not as per constitution. It is illegal. So, but being considered that, my lord, Supreme Court has said whatever investigation, whatever status it is, those matter has to be transferred to the foreigners tribunal. Now, can we, my lord, question the jurisdiction of the tribunal that this reference was not correct? This reference is wrong. We cannot question now the jurisdiction of the tribunal because tribunal has jurisdiction, got jurisdiction only as per the direction of the Supreme Court. My lord, if suppose this case, my lord, there is no inquiry at all, suppose no inquiry at all, but Supreme Court has directed this matter has to be sent to the foreigners tribunal. Directed to this matter to be sent to the foreigners tribunal. Now foreigners tribunal is bound to take the, my lord, bound to take the case. Now we cannot question that, no, you have no jurisdiction. If the Supreme Court is conscious about this matter, Supreme Court knew it well, that the procedure are all illegal, there are defects in the old cases. So knowing all this matter to transfer. So now if we challenge, we have to challenge the Sarbananda Sonowal matter. We have to challenge the Sarbananda Sonowal that no, each and every case has to be looked differently. Then only you can ask to transfer the matters to the foreigners tribunal. Without going to each and every case separately, you cannot transfer the matters to the foreigners tribunal. So that is my submission, my lord, in that case. Secondly, my lord, on merit. Merit, my lord, only thing is that the link document. The other specs, my lord, voter list, even though we accept, my lord, even though this 1966, 70 voter list are accepted, 97 is accepted, my lord. The only link document, what is the link document of the petitioner? To link herself to her projected father. That is the Gaon Bura certificate, my lord. 2 Gaon Bura certificate. And first Gaon Bura, my lord, DW2, he is aged about 29 years. And his knowledge is personal knowledge, not on the basis of any record. So this was deposed in 2017. His, my lord, knowledge, personal knowledge goes maximum up to the, my lord, 2000, not beyond that. 29 years maximum. I accept, my lord, suppose he has knowledge from his childhood, then it may maximum to 1990, 1995. Not beyond that. And secondly, the tribunal has rightly said, my lord, they have said that they know that they are the resident of this area, this place. That is the only thing. And, my lord, how the Gaon Bura certificate, Panchayat certificate has to be proved. That is laid down in numbers of cases by this honorable court on the basis of, my lord, Rupjan Begum of the Supreme Court, where it is said, my lord, the certificate has to be verified in 2 stages because these are private in nature. These certificates has to be verified in 2 stages. First of all, my lord, the authenticity of the certificate itself. Secondly, my lord, authenticity of the contents of the document. The contents of the certificate has to be proved by exhibiting, my lord, contemporaneous record or, my lord, any inquiry that an inquiry was properly met after due inquiry, after considering all these facts, my lord, that has to be seen. Now this Gaon Bura, my lord, Gaon Bura. The Gaon Bura's evidence is that, my lord, DW2, he said, I'm working as Gaon Bura village so-and-so, exhibit so-and-so signature. Where and when do you, I know the opposite party so-and-so since childhood. So he know opposite party from childhood. She resides in the village so-and-so. Her father's name is Tukumia. She married with one so-and-so, so-and-so. I had issued certificate in exhibit so-and-so. He has not brought any record, contemporaneous record, to prove the documents. The document has to be proved on the basis of contemporaneous record, not on the basis of personal law. So if now, my lord, if the link certificate, both the Gaon Bura has deposed on the same way, if both the certificates are not there, link certificate, there is nothing to say, nothing to link herself to the projected father. His father may be there, the projected father's list of 1966, 70, 89, 97 may be there. But it is the duty of the petitioner to project her, my lord, prove that she is the daughter of that, my lord, projected father, whose name was there in 1966, 70, or 89, 97. And with regard to wrong mentioning of, my lord, in the notice, this court has said, my lord, the numbers of the cases are there, my lord, where it is said wrong mentioning of stream in the notice will not, my lord, deviate any manner These are the points, my lord, I'll furnish the my lord written, the judgments, 2-3 judgment. This is 2017 2 GLT 996, my lord.
What point?
That wrong mentioning of, my lord, stream in the notice,
Name of the parties?
my lord, Ananda Ghosh, 2017 2 GLT 996.
The Ghosh.
Yes, ma'am. Ananda. Para 13, it is said,
What is the citation?
2017 2 GLT 996.
996,
Yes, ma'am.
paragraph?
Para 13, my lord, 1-3. Okay. This said, having regard to above, we have no hesitation to hold that when the reference was as to whether petitioner was belonged to 1971 stream. Non-mentioning of the same, wrong mentioning of the stream of foreigners to which the petitioner belongs to the notice would not vitiate the ultimate conclusion reached by the tribunal. Are you not? Okay. Another judgment, my lord, because I am relying this judgment only for the notice purpose. Otherwise, my lord, I have submitted. This stream was not compulsory in my lord, as per the my lord, the IMD. So it is a IMD reference of that time. In fact, this judgment, my lord, Aziz Mia, WPC 2370/2023.
This spelling is?
AZIZ MIYA.
Yes.
WPC 2370/2023, my lord.
Decided off.
Decided on, my lord, 9/6/2023, 09/06/23.
Yes.
Here, my lord, in fact, here the question was, my lord, whether, my lord, the reference, if defective, 6671, if the reference is defective and the tribunal determines him to be a foreigner, prior to that, is it the duty of the tribunal to remand back the matter for, my lord, correct reference?
Defective reference?
Yes, if reference is defective, suppose, my lord, the stream is not mentioned. In that case, whether it is the tribunal can send back the matter to the my lord, referral authority for fresh reference. That case was there. In discussing that it is said, my lord, once the tribunal decided to be foreigner, it need not be sent back because it will, my lord, it will no way prejudice the petitioner. Because, my lord, just I'm reading one para 10, my lord. Clause 2 of the Foreigners Tribunal Order 1964 provides that central government may by order refer the question as to whether the person is a foreigner or not a foreigner within the meaning of Foreigners Act 1946. So the statute has not asked whether you are a foreigner of 66 to 71 or, my lord, post 71. Foreigners Act does not provide it. So simply they say it's, my lord, whether you are a foreigner under 1946 Act or not. It is the tribunal to decide in that case, to tribunal to constitute the purpose of, and central government by an appropriate notification delegated the power to so and so, so and so. That was the point, my lord. Then para 11, it is said, reading the provision of 1964 order indicated that also leads to conclusion that the report of the investigation authority that may have been submitted as to whether the suspected person is a foreigner or not would be merely indicative in nature and cannot be said to have attained a finality on the status of the suspected person. So it is not a finality, my lord. It is the tribunal who is to give the finality, whether it is of 66 to 71 or post 7. So that point was decided. So my submission is, my lord, that to aspect maintainability, I have already argued, my lord. Secondly, my lord, the petitioner could not establish her link to her projected father by any my lord, record or any document which is admissible and which is proved, my lord. So the opinion of the tribunal may not be interfered by this honorable. Not-
My short submission, the reply submission is that, my lord, my friend has cited some judgment. The last citation he has cited on a point that when the investigating report is enough, IO report is enough, and then the tribunal can proceed. And here in this case, my lord, the LBO report, paragraph clause 15, 16, totally blank. No whisper in which period the suspected person has entered, totally missing. My lord, and this case, my lord, has been detailed discussed, your lordship, in the Rafika Bibi case. I got this copy, one copy of the judgment, my lord. My lord, in under paragraph 29 of the judgment, the full bench has been fully discussed. Paragraph 93 of the full bench, then my lord, 95 and 96, 97, 98 has been discussed. And my lord, in 98, my lord, there is one, I want to read the, my lord, paragraph 98 quoted in this judgment, my lord. The reference by referral authority also cannot be mechanical. The referral authority has to apply his mind on the materials collected by the investigating officer during investigation and make the reference on being satisfied that there are grounds for making such reference. The referral authority, however, need not pass a detailed order regarding his satisfaction. An order agreeing with the investigation would suffice. My lord, I have gone through the record. There is no such order passed by the learned tribunal that holding that the materials are sufficient and he is satisfied. That part also not mentioned. And notice has been issued, my lord, with 2 charts. My friend has also pointed out, my lord, then my lord, ultimately lordship has paragraph 32 and 33 and 35 has held that the reference in para 32, it is lordship has quoted, on perusal of the proceeding the tribunal, we do not see any exercise being undertaken with the tribunal. The tribunal was prima facie satisfied about the existence of main grounds on the doubtfulness of the nationality of the proceeding before issuing notice to the petitioner. Para 33, therefore, keeping the aforesaid principle laid down in the case of Muslim Mandal, we have no other option but to hold that the tribunal made an error in proceeding against the petitioner, as there was no any specific finding arrived at by the inquiry authority, and that the petitioner is an illegal migrant. Then, my lord, the paragraph 35, be that as it may, we are not entering into the merit of the case as far as the appreciation of the evidence is concerned, as we have already held that the initial proceeding itself is vitiated as there was no proper reference, and in fact, the reference was contrary to the finding of the inquiry report. The petitioner is suspected to be a foreigner based on the documents produced and examination of local witnesses. My lord, Lordship, my lord, I have got one copy, my lord. I'm referring to lordship. Then, my lord, my friend has referred one Ananda Ghosh case. Non-mentioning stem is not required. My lord, this is also against the full bench judgment. In full bench judgment, Muslim Mandal. My lord, there is clear in paragraph 124 of the Muslim Mandal judgment. Yes. My lord, in paragraph 124 of the Muslim Mandal, my lord. iPad আছে iPad এর মধ্যে যার মিলটা করে নেন না তো এটা বের করে কি করতে ও করে নেন my lord my case is covered fully by the Rofika Bibi case, my lord. And my friend has saying that when reference is even the reference is defective for and trial has trial court has decided to proceed. No prejudice will cause to the petitioner, and so no legality, my lord. That, my lord, against the principle, my lord, of the principle laid down in the full bench decision and the other decision also, my lord, trial, the paragraph 98 clearly said that tribunal is to record its satisfaction. That is totally missing, my lord. Marshal Mandal, paragraph 98, my lord. And that point has also been, Lordship has discussed in the Rofika Bibi case. And in para 124 of the Muslim Mandal case, there has been categorically stated that non-service of such main grounds, though mandatory required, amounts to denial of reasonable opportunity to defend herself, thereby violating basic principles of national justice. There was the main grounds that should be specific, not this way. This is a back charts. How the main grounds can be given in a back way, my lord. That is my point, my lord. So, my lord, I think, my lord, this much is sufficient, my lord. I do not want to make. My lord, my lord.
Petitioner also had so and so of the respondents. Arguments are concluded, judgment is up.
Deep love legislators.
The bench is only till 2 o'clock, this, 1 o'clock. I don't think we'll have time to take up any other matter. To the members of the bar, we can't take up any other matters because of paucity of time. And Mr. Payang, if you get this copy, please give to us. Well, once we read this, we'll be remembering, otherwise it doesn't. It can't be retained.
About data compilation to manually to chart that banner relevant কাগজ কিনেও দি দিও একটু কোয়েশ্চেন দিতে পারো এই বছর থেকে যেখানে আমরা এখানে কামি না লাগে এখানে দিই ও ঠিক আছে এই যে ভালো লাগে অনেক শুনে কি আছে কি নাই বলে কইছে এখানে করতে গেলে চার্ট বানিয়ে দিবা চার্ট বানিয়ে দিবি এই একটা ফর্মেট বেশি লিখবো এই ফর্মেটটাতে দিয়ে দিবি এটা আমি একটু ল্যান্ডস্কেপ বানিয়ে কিনে ডিস্ট্রিক্ট ওয়াইজ মানে দিল এখানে হেডিং দিই এখানে কম্পাইলেশন হ্যাঁ 93 আইছে কিন্তু এখানে ছবি বানাবো লাগবো খুব রেগুলার Yes. We'll try. দুসপ্তাহ পাই যাবে আজি হল 3 তারিখ না ঠিক বাট at 2 p.m. Saturday. Look. Look. You can copy. Yes, ma'am. Yes, ma'am. It can be done, madam. Yes. Malad.
Yes, Malad.
Malad.
I come in only one.
Just
Okay. Based the information that.
পইচা ফেব্ৰুৱাৰী ধৰ্ণা বন্ধ হোৱা আকৌ দৰমহা বন্ধ হ'ব ফেব্ৰুৱাৰী আহি গৈ এক্সটেনশ্যনৰ কথা আহি
Flush.
Well, I'm just indicating I'm led by my senior. He's having some personal difficulty. Malad. On next day he'll come. But till then, Malad, till now, their intention is to do Malad. Although not to that extent, but they will do. Lost. That is one way. That is not.
Flush. Yes.
Yes.
In fact, in this, my brother can have instruction on this on priority basis, my lord, because it is tomorrow, day after tomorrow.
As regard
True.
scanners are not there.
No, I'm saying not only the scanner, totality. In what manner the member of the tribunal can send the records to this tribunal with its scanner, computer, everything, my lord. That can be done in a
That-
priority
that-
basis,
that
my
we
lord,
have
because
to-
it
that
is
we have to see.
otherwise
Otherwise-
affecting the functioning of this court also. Correct. That's true, my lord. That's true.
100, Manoj. Hmm. 2.5.
2 crore. 2.5 crore.
That's-
Hmm.
As regard the,
And
as
what I'm
regard the-
saying is that, Milord, at least we can start the thing.
As regard the,
I'm not
as regard
saying
the
you give it
SOP,
tomorrow or day after tomorrow. At least we can proceed because since it's a regular, fine, my lord.
Yes, yes.
Yes, I have already taken a note, my lord.
As regard the SOP, Malad, I have spoken, we have discussed. But the problem is that my people, the officers, they are hesitant that how the officers can Malad, have a regulation that how the judge will function. They have some difficulty. It is by the tribunal. No, here the secretary or the commissioner of the home department, they are to make. As regard the functioning of the court.
In fact,
I'm indicating that.
In fact, in the
It will-
Administrative Tribunal Act also,
Some
there is a
deliberation.
rules of practice, my lord. Yes, procedure and practice.
There has to be some deliberation on that, Malad. Then only they will proceed. Malad. No, we'll wait. No. I'm not disagreeing, Malad. Ultimately, the thing is that how the procedure they will proceed. We'll see on that. Malad.
আগতটো obsolete হৈ গেল।
what I am submitting on, some deliberation is required on that. We have to, because the requirement has come, now necessity has come. Yes. Raised. Yes. Petitions, Hajiras are. Index. Index. Not at least. Officially, it doesn't go. Okay. Hmm. Correct. Hmm. Training. Civil code procedure ওখানে পড়বো না like. Particular instance okay. আসলে আমাদের ব্যাপারে তাকে বুঝে গেছে না একটু রিজার্ভে ইস্যুস which কপটা বন্ধ হওয়া ট্রেনিং একটা করা ভালো নেই এগুলো সিরিয়াস কথা না সিরিয়াস কথা একটা নন সিরিয়াস কথা এগুলো It does me in order to discover or obtain proper proof of relevant fact. A penetration he places in any form at any time. Of any witnesses of the station. Any parents to real no other production may document of the and other project at least shall be proviso. Then must be based upon a particular Judgment is, judgment. Yes. Malak.
86.
Commission. Commission. Malak. Reported deposition by the, to be evidence in suit. Okay. Hmm. Hmm. Yes. Other party, it has to be based on, judgment has to be. Proviso said, based on the evidence.
It's like a judgment becoming void for the procedural infirmities on the face of it.
Well, correct. That's.
Hmm. 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 Yes. Yes. He used to regularly come. He used to.
Mhm. These things have become
I
necessary.
think with the infrastructure things, this should also go parallelly, my lord. But your lordship, what has fallen.
No, that's true, that's true. Ultimately, these are issues, Malak, going to the root of the matter. Something is going on, bro. Something is going on. I don't know exactly, but something is going on. But Lordship, Lordship, that is why my lord, whatever is in my mind, I have expressed so that I can take it up with him. Because the SOP or the procedure, my lord, that I'll definitely take up. Although it has not come, it has fallen from your lordship, my lord, I'll definitely take it up.
Dossier to.
My lord. No, it is required. It is required. In fact, the civil court procedure is there. Civil court procedure is there. To explain the period, they have to in 5 heads, my lord, mention the date. Tribunal. That is the primary thing. That is the primary thing. That has to be there. Good. Yes, madam. In the register, it has to be entered. That has to be. That has to be. Another 4-5 years, that's right, that's right. Well, that's ultimately the system fails. The entire system. That's true. Twenty-four. 34. Seven, six, seven.
700.
Not. Which is coming up. Yes. But